Today, I'm going to give you the steps to follow if one day you wake up and all of a sudden your business partner locked you out of a bank account here in Florida. I'm Santiago Cueto, a board-certified international business law expert. I've helped Fortune 100 companies, foreign governments, and entrepreneurs win their legal battles in court. Being locked out of a bank account is shocking and stressful. Imagine this, you trusted the person you built a company with, and now without warning, you find yourself blocked from the company's money. It feels personal, but make no mistake, it's also a major legal issue. So let's walk through the steps you need to take calmly, strategically, and with your rights protected. First, stay calm. I know easier said than done, but overreacting, sending angry texts, making threats, or storming into a bank will only hurt your case later. Instead, start by documenting everything. Save copies of any emails, text messages, or account notices you've received. Write down the date and time you discovered you were locked out. List every action your partner took that restricted your access. This documentation could become critical evidence later in court. In business disputes, paper trails win battles. Next, you need to confirm your ownership rights. In Florida, if you are a co-owner on the business bank account, a registered officer of the company, or a shareholder, member, or partner under corporate documents, then you have a legal interest in that money. It's important to immediately review the company's operating agreement, shareholder agreements, partnership agreements, bank signature cards, and any corporate resolutions regarding account authority. Sometimes one partner has been given sole authority over the bank account, but even then, they still owe you fiduciary duties under Florida law, meaning they can't just steal or misuse company funds. Knowing your exact position helps you plan your next move. Once you confirm your rights, the next step is to send a formal written demand. A demand letter should be professional and non-accusatory, clearly state that you have been locked out, request immediate reinstatement of access, and request an accounting of all bank transactions since the lockout. This puts your partner on notice and starts building a legal record. In many cases, a strong but professional demand letter will lead to a resolution without going to court. If they refuse, you're better positioned for legal action. If your partner refuses to give you access, or worse, if you suspect they are draining the account, you may need to act fast. In Florida, you can file for an injunction to freeze the bank account and freeze further transfers, a lawsuit for breach of fiduciary duty, conversion, or even civil theft, and a request for accounting to force disclosure of how the money was used. Courts take financial mismanagement between business partners very seriously. If you can show that you have legal rights to the account, you were wrongfully locked out, and that there is a risk of harm or asset loss, the court can intervene quickly, sometimes within days. In more extreme cases where trust has completely broken down, you can ask the court to appoint a receiver. A receiver is a neutral third party who takes control of the business's assets, manages the bank accounts, and reports back to the court. Receivers are often used in partnership disputes in Florida to preserve the company's value while the lawsuit plays out. It's a powerful remedy, but it's serious, and courts don't grant it lightly. You'll need strong evidence of mismanagement or misconduct. Now, let's be honest. When a partner locks you out of a bank account, it's often the beginning of the end of the relationship. Even if you regain access, trust has been broken. You need to seriously evaluate. Do you want to continue this partnership? Does the company still have a viable future? And should you push for a buyout, dissolution, or sale? In Florida, business owners can file for judicial dissolution, which is basically asking the court to unwind the company when partners can no longer operate the business together. It's tough, it's emotional, but sometimes it's the cleanest solution for everyone involved. Finally, Whether you resolve the dispute or go your separate ways, use the experience as a wake-up call. Make sure your next business has a clear agreement about bank authority. Require dual signatures on withdrawals over a certain amount. Set up regular financial reporting to all partners or owners, and include clear remedies for breaches in your partnership or operating agreement. In business, as in life, trust is critical, but trust without verification is a recipe for disaster. Set up systems that assume the best, but protect against the worst. So if you ever find yourself locked out of a business bank account by a partner in Florida, remember, stay calm, document everything, act quickly and strategically, and most importantly, protect your future, not just your present. Because in business, protecting yourself is protecting what you've worked so hard to build.